Moving to item 22, AB 2546.
Thank you very much, Mr. Chairman and members. AB 2546 will ensure that the networks and the senders of false and deceptive spam emails are held liable for their unlawful conduct, expand what constitutes false and deceptive email content, and enable the courts to order injunctions against spammers. It is common for advertisers to send unsolicited commercial emails to consumers. Often they will contract with spam networks to distribute emails to consumers. Those spam networks in turn contract with third parties who actually send out those emails. Often the senders will use methods designed to circumvent spam filters or mislead consumers. Among others, these methods include sending emails from multiple domain names, altering the from line to mislead the recipient about the identity of the sender, copying headers from legitimate businesses and placing them into the email, or simply providing untruthful content to mislead a consumer. Under existing law, advertisers are strictly liable for false and deceptive spam. However, the actual senders of the emails are not liable for sending the unlawful spams. This bill, AB 2546, will strengthen California's prohibitions on false and deceptive spam emails in several ways as follows. 1, holding spam networks and the actual senders liable for false and deceptive spamming. Number 2, applying the law to falsehoods or misrepresentations in the body of the email, not just the headers. Number 3, establishing that truthful content in one part of the spam does not cure falsity in another part. 4, prohibiting spamming from multiple domain names for the sole purpose of bypassing spam filters. 5, prohibiting from names that misrepresent who the spam emails are actually from. 6, authorizing the courts to impose injunctions to stop unlawful spamming. And finally, allowing district attorneys and city attorneys to bring actions against unlawful spammers. With that, I respectfully ask for your vote, and I'll ask my witnesses to introduce themselves.
Very good, thank you.
My name is Dan Balsam. I'm an attorney in California with a marketing background, and I support this bill for the reasons Assemblymember Chow addressed. One thing in particular I would really like to stress is that under current law, false and deceptive spam is already legal, and the current law has not killed e-commerce or technology business in California. All this amendment does is, for the most part, it clarifies existing law by providing examples of falsity and deception, thereby providing guidelines to marketers. What we're telling them in this bill, here's what you have to do to not get sued. Accordingly, the statute also has, it authorizes a 90% reduction in the liquidated damages. This is part of the current statute, but it's a little vague. What this bill does is tell the e-marketers, here's what you have to do to get that 90% reduction. This is a benefit to the e-marketers by reducing vagueness and providing clarity. So most of this bill is clarifications. The couple substantive additions that Assemblymember Chow mentioned, allowing standing for district attorneys and city attorneys, holding the actual senders liable, because under current law they're not. The actual advertiser is strictly liable, but the person, the entity who actually bought a list of email addresses on the dark web that actually forged the headers, under current law, that person is not liable. I believe it's an omission in the current statute that should be fixed. And since the current law addresses falsity and deception in the headers, there's no reason why it shouldn't address falsity and deception in the body of the emails as well. So really, that's what this bill is attempting to do. It's to tighten up some of the gaps in the current law.
Very good.
Thank
you for the testimony. Next witness in support.
Good afternoon, Chair and members. Danielle Kanda-Kaiser on behalf of Common Sense Kids Action. I would align our support statement with my colleague and the author, specifically the clarification that the bill provides, as well as reciprocity for consumers. We urge your aye vote. Thank you.
Thank you. Others in support? Is there anyone here in opposition? Yes. Please come forward. And please come up. These.
Thanks.
You can sit over, sir. There you go. Give me some. Please begin, and I've about 2 minutes each. Is
very quick. Good morning, good afternoon. My name is Bennett Kelly. I'm with the Internet Law Center in Santa Monica. I am also chair of the California Lawyers Association Technology, Internet, and Privacy Subcommittee of the Intellectual Property Committee. I am speaking here solely in my personal capacity. I'd like to clarify that this bill, no one likes spam, and this bill isn't about spam. It's about regulating deception in commercial email, and applies to spam and non-spam alike. What is deceptive is to say this is a clarification. It is a complete rewrite of existing law, primarily to reverse two court decisions that went against the plaintiff's bar. And so it's trying to win in court, winning here what they couldn't win in court, including reversing a unanimous Supreme Court decision that held many provisions in this bill were not deceptive. So that's the first thing. They're trying to reverse a unanimous decision in the Clefman case. So this law will only benefit a small group of plaintiffs' lawyers who just focus on email cases, about 6 of them. They'll have no consumer benefit because the Supreme Court has already said this is not deceptive. And there's no harm to the consumer, but there'll be harm to businesses because it greatly expands the risk to them for litigation. The amount of exposure they will have under this versus existing law is exponential. I've talked to my clients. I know one client, a very successful and by-the-book email who markets his e-commerce operations. He anticipates he will have to shut down 80% of his business because he will no longer be able to solicit by commercial email. And he doesn't use spam. He uses opt-in email. And so I would suggest 3 points of clarification or amendments. One is the bill allows you, it has a language to clarify that it applies to in commercial mail, applies to any other solicitation, and that could be interpreted to include nonprofits or even political solicitations. So I would strike that. The second is the language that they talked about, including adding falsity to the body of the email. What that would do would be completely rewrite existing false advertising law. Currently, false advertising law requires some element of intent. In addition, under Prop 78, requires that the person who sues have some form of personal injury from the allegation. That was passed because of a widespread abuse. What this bill does is circumvents that without any intent element, and this is strict liability, no requirement of harm. The last thing I would ask is to not reverse the Supreme Court decisions in Clefman. A lot of these provisions in this bill deal with the email filters. Don't reverse. A 7-0 Supreme Court decision is the right decision. Don't reverse it. Thank you.
Yes, sir. Welcome.
Hello, my name is Jared Gordon, and I am the co-vice chair of the Internet and Privacy Law Subcommittee of the California Lawyers Association Business Section, but I am here also in my personal capacity and not my capacity as the co-vice chair. Now, I'd like to identify for you what I think is really central to this bill, which is that it is not merely a small technical change clarifying with examples what existing law says. In fact, what it does is substantially expand the number of private right of action claims available under Business and Profession 17529.5. So although there are more than just the list I'm about to give you, I'll highlight just these because I think that all of them have many different potential examples that do not represent even false and misleading potential uses, let alone materially false and misleading uses, which is what's required under federal law. So the use of multiple domain names in mailing. This is a common practice. It's used by virtually every business with a substantial amount of email that it sends, including by nonprofits and political actors. If you talk to whoever does your campaign mailing, they probably do multiple domain names as well. It's just standard practice. It's not really, there's actually case law that says it's not false and deceiving, including at the Ninth Circuit. And, that's one of the things that there's a private right of action granted for in this bill. Generic text in the from line. So identifying someone as a seller of cars as opposed to the specific business name is something that's given as a purported example, but really there's a private right of action created if there's a generic text that does not accurately describe a business. Related, but I think distinct private right of action is created in the event that someone uses a fictitious business name as part of their from line. Now, the fictitious business name is something that California law already provides for. Generally, businesses are allowed to use it for virtually any use that they might use for their name. But as I read this bill, it potentially would make the use of a fictitious business name in the from line an actionable claim under 17529.5 as amended. Further, it also prohibits nonsensical text. So sometimes emailers will add text to bills, emails, and sometimes that text is used to make it more difficult to filter those emails by automated filtering systems. But sometimes the filtering systems are wrong, and they simply misidentify what might actually be a quote that goes along with someone's signature. It could be, for example, the text of the First Amendment that gets added to the end of an email because someone truly believes in free speech. All of those might, in the context of a commercial email, seem nonsensical, but in fact they aren't. And this bill potentially risks our law imposing sanctions on people who are including the text of the First Amendment, including biblical text in their emails. Anything else that might, in the context of the overall body of the email, seem nonsensical. And I think that's an unacceptable outcome under the First Amendment. Finally, it potentially creates a private right of action for the use of RE: in the subject line. And as a lawyer, I will simply tell you that my bills often use the phrase RE:, and it simply means in regards to. And while it is often used automatically in email as a reply message, it also can mean in regards to, and many people use it for that purpose. This is therefore a content-based restriction and poses significant problems on a First Amendment level, and frankly just does not really relate to a materially false or deceiving subject
Thank you, Mr.
line.
Gordon. I appreciate it. Others in opposition, please come forward and state your name and.
Cyrus Devers for the Internet Business Coalition in opposition. Thank you.
Thank you.
Ross Buckley with the Personal Insurance Federation opposed.
Steve Carlson for the Data and Marketing Association and the Association of National Advertisers in opposition.
Very good. Thank you. Others in opposition? Seeing no one, bringing it back to our committee. Yes, Senator Dodd.
Yes, Assemblymember Chow, I like what you're doing here. I do have concerns about the private right of action. That's clear for me. The other one is where there are no damages. I have a bill not totally similar, but those are issues that I'm working on too, as well as making sure that there are safe harbors or making sure that people that are damaged are the ones that can not just anybody. And so I'm kind of interested in your thoughts behind the comments of the people that are concerned about your bill.
Sure. Thank you for your question, Senator. Let me address the private right of action issue as well as one other issue that was raised, and then I'll turn it over to my witness for the rest of the issues that's been raised. With respect to the private right of action, this bill does not create a new private right of action. In fact, current law already provides for that, and it's a BNP section 17529.5. That code section clearly provides for the right of private right of action. All we're doing now under this bill is to essentially allow standing to be granted to the district attorney and also the city attorney to bring actions. So that's exactly what we're doing. We're not adding a new private right of action to the bill. Now, with respect to the, I think there. Oh, okay. Yeah. Let me also address the issue that was the other issue that was regarding charitable and political organizations. There is no intent to include those entities into the bill, and we're willing to modify or amend the bill to actually provide exceptions for those organizations as well. So that could be fixed very easily, and in fact, we haven't seen any on charitable or non-profit organizations having to report this kind of incidents. Now, let me turn it over to my witness to address the other issues that's been raised regarding the court decision, the body of the email, and also multiple domains. That's okay, if it pleases the court, the chair.
That would be fine. Thank you. If you could be as brief as possible, and that we're running into a time problem.
Sure. First of all, this bill does not apply to false advertising in general. It only applies to false and deceptive spam. The whole point of this chapter, this bill, and the current law is about unsolicited commercial email. So the starting point is that it's spam, and point 5 is that it's false and deceptive. So this bill in no way, nor does the existing statute, address advertising other than spam, unsolicited commercial email. Second, The bill does expand the scope of the statute a little bit. It's not a new private right of action, but it does, because there's already a private right of action for recipients of spam, but it does address falsity in the body. That's correct, because if we're going to address falsity in the headers, why shouldn't we address falsity in the body? Falsity should be addressed wherever it is. As far as multiple domain names, that was the other big issue that was raised. The statute does not categorically make multiple domain names unlawful. It's what makes it unlawful when the only purpose for doing so is to avoid spam filters. So an example that I'd like to use on this point is the Walt Disney Company. They have thousands of brands and products, and nobody is saying that Disney should not be able to use the LionKing.com and ESPN.com and the LittleMermaid.com and whatever else they have. There's a valid reason to do so because there are real brands behind it. What this bill is trying to address is a spammer who sits alone in his garage generating 100 nonsensical domain names that have no inherent connection to the product being advertised and uses all of those domain names to advertise one product. This happens all the time. And the only reason to do this is to avoid spam filters, because filters learn. Filters act as our agents to recognize and block spam, whether we use it ourselves with software plugins or whether it's at the Yahoo level or the Comcast level. There are filters that act to protect us, and using multiple domain names is an attempt to evade that. The Supreme Court did rule on this question. But the case never rose up through the California courts. No jury ever weighed in on whether this was deceptive. There were no findings of consumer input in any manner whatsoever. The question was referred to the California Supreme Court by the Ninth Circuit. So the California Supreme Court did say that, and this bill is attempting to, not trying to hide it, is attempting to reverse that decision to the extent that it applies to nonsensical, illogical use of multiple domain names. If there's a valid reason to use multiple domain names, great. Procter & Gamble has 1,000 consumer products. They can have Tide.com, Downy.com, CrestToothpaste.com, whatever their products are. No problem. There's real brands behind it, and when a consumer gets an email from Tide.com, they know who it's from. The issue is hundreds of nonsensical domain names meant for no purpose other than to avoid filters.
Very good, thank you. Senator Glazer.
Thank you. Thank you. I think we're all sick of spam, and there's no doubt that the goals that you're trying to accomplish in this bill are something that I certainly am supportive of, and I'm sure my constituents are as well. And I do find this to be a fairly complex area. I know the bill was just referred to us this past week and hasn't given us a lot of time to kind of delve into a lot of the issues that are being raised. But there are a couple that do trouble me here in this bill, and I wanted to ask you about at least one of them. And that's the issue of burden of proof. You seem to be putting the burden of proof onto the business. And before you answer that, let me just add one more thing, which is that a lot of the challenges that we face in these types of enforcement actions is that you may have a couple bad apples, but we don't want to have it affect everybody else out there, right, that's doing reasonable things under the law. You may not like what they're doing, you may like what they're saying, how they're doing it, but they're reasonable under the law. And we have to make sure that we don't, when trying to catch the bad apples, encompass those who are engaged in legitimate business practices. But you do create a standard of proof that doesn't, it seems like it's kind of reversing things here, and wanted to have you address that.
Are you referring to multiple domain names or reduction of names? Okay. If the law were enacted in the way that it currently appears in the bill, then my belief is that no attorney would bring a lawsuit against, using the Disney example, where that were the only violation. I mean, if Disney had false subject lines, that's a different issue. But as far as multiple domain names is concerned, if the statute read as it appears in the bill, where I think an attorney that brought a case under those grounds would be subject to sanctions for a frivolous lawsuit. I think there's a deterrent on that side, because I don't think anyone here, I don't think any reasonable person would claim that Disney shouldn't be able to use multiple domain names. If a lawsuit were filed, then the defendant, as you said, would have a burden of proof to prove that there's a valid reason, but that sort of burden, but a defendant has a burden of proof in a lawsuit anyway. That's the nature of being a defendant. So,
well, it would seem that under the way the bill's written, that why should, well, first of all, I find it fascinating that you're using an example of only an extreme attorney, would take this as a cause of action, and they'd be guilty of malpractice if they conducted themselves. And yet that's the same thing you're trying to encompass in the bill that you're doing, is to go after these bad apples. I mean, if you create the standard, anybody can use it in any way they want to use it, right? And so you're creating a standard here that says that the defendant has to have the burden of proof to show that they were engaged in legitimate business reasons, but the lawsuit could say, well, the law says you have to, that's the burden. Prove it, that you weren't trying to spam people. Prove it.
Well, spam is already, I mean, whether or not it's spam is sort of a separate question, whether or not there really is direct consent and everything that goes with spam. But specifically for the multiple domain name issue, you're right that a plaintiff that alleged multiple domain names for the sole purpose of bypassing filters, you're right, a defendant would have the burden of saying, no, I have a valid business reason and here's why. But again, I think the plaintiff would, in that scenario, would have, or the plaintiff's attorney would have a serious problem with bringing a frivolous lawsuit.
Okay. I appreciate that feedback. The damages seem very high for what you're asking for.
The damages are part of the existing statute.
Just on my own time. And I am troubled. I have no problems with the expansion of the enforcement side to city attorneys and the DAs. In fact, I think that's the better course of action for a lot of places in our law. And I don't like the private right of action, because if you're violating the public's trust, it shouldn't be a private individual engaged. It should be our law enforcement agencies and our law enforcement officers who are there to protect our interests. So listen, if the main statute came back with a private right of action, I probably wouldn't support it today. So it's hard for me to think about any kind of expansion that only can create more jeopardy out of this. But I agree with what you're trying to do with the bill, and I'd like to find some way to find that common ground as we go forward.
Yes, Senator Allen.
Wait, so I just want to clarify here, because we have one side saying that this is basically going to create a strict liability private right of action that's going to benefit just a niche group of plaintiffs' lawyers. You're arguing that's not the case. How do I get a little more clarity as to?
Well, there is strict liability under the current statute. The legislature imposed strict liability, and courts have upheld it because often it is hard to track down the actual spammers. So strict liability is already there. The private right of action is already there too. Again, I believe that's in part because the legislature recognized, as part of the current statute, that recipients are in fact harmed. And while it would be great if the Attorney General and the Federal Trade Commission did more, they have lots of things to do. It's my belief that if you want to, that the people who are harmed should have the right to stand up and do something about it, which certainly does not preclude the FTC or the Attorney Generals or anyone else from doing anything about it as well.
Okay, so Mr. Kelly, I think you were representing to our staff that it was creating this, but I guess what you're saying is that it's already in law.
Well, I mean, this bill is being presented as a clarification of existing law. And existing law enumerates 3 major categories in which you can sue if there's falsity. And what this does is add about 3 to 4 to 5 more, and in areas where courts have already said this isn't deceptive. So areas where courts have already found there's no harm, these things are being added to benefit, Mr. Balsam and other lawyers like him. There's only a handful of them, and creating, to your question about a presumption, creating a presumption that if you use multiple domains, that somehow you're deceptive. And so then you have the burden. You're going to get a letter from them saying, prove it or settle with me because I think I have a claim. And, I don't think that the California legislature wants to count on the kindness of plaintiffs' lawyers here. But let me tell you who uses multiple domain names. The California Lawyers Association uses multiple domain names. The Clinton Foundation uses multiple domain names. Yeah. You go through your spam folder and look at all the emails that are filtered. A lot of them are, they're not spam. They're emails you can send it to. A lot of them use multiple domain names for good reason, just because email filters aren't based on deceptive. They're not based on policy. They're just based on a lot of things, and none of them which have anything to do with deception. And here, we're just talking about deception.
So how can we clarify? So, I mean, I know we use MailChimp, Constant Contact. We're using lots of different email domain names for different segmented lists.
MailChimp often uses multiple domain names.
I mean, surely that's not what you're trying to get at here.
No, we're not trying to get at multiple domain issues, at large, but we're just looking at folks who use multiple domains to basically deceive the system or basically bypass the spam filters. And that's the, the gist of the bill. And let me just also just add to, there were questions about the new quote unquote private right of action. And we're not creating any new private right of action for any individuals. We are just simply allowing the district attorney and the city attorney to be able to bring lawsuits on behalf of the public. But the only thing that we're adding is the body and also the header situation that we talked about. So we're not creating any brand new private right of action
I thought
for
there was
individuals.
related to the false and deceptive part.
Yes.
They're examples of falsity and deception. The current statute, the current statute was written in 2003. There's been a lot of learning since then. What's there right now is it's good. It's a little vague. It doesn't really give examples. That's the purpose of this, both for the examples of the falsity and also to get the reduction in damages. This statute, by providing examples, helps fill in the gaps of the current law. It tells marketers, here's what you need to do to not get in trouble.
You're not addressing vagueness. You're trying to reverse court decisions that explicitly said what you claim is wrong. It is not deceptive.
Well, if
You're trying to make money where a court said there's no harm.
Okay, fine. We'll answer the question, Senator Allen.
Well, I was literally just put on this committee a day ago, and I'm dealing
That excuse won't go, that does not go very well. You're done with that excuse, Senator Allen.
But it is I really would think, I get the sense of what you're trying to get at here, Mr. Chow, and I'm very sympathetic to it as someone who receives a lot of spam email. But I do think that it would seem to me that you want to clarify a bit relating to different domain names as it relates to legitimate contact. And I guess the devil's in the details in terms of how you differentiate, but it seems from the discussion and what I've seen in the analysis that it's a little too vague. I was wondering, did the committee work on this at all and offer any amendments on this?
Well,
question?
this is double referred to judiciary next week. It was where it will be going, so we don't have an opportunity to add amendments to it now. We can certainly get a commitment from the author on certain amendments, and if they're not, we can certainly bring it back to this committee for review and at any particular time. So that's an agreement that we can work with to see how we can do that. And I'm certainly willing and happy to do that for the author.
I'm definitely willing to commit to
I think we need
continue
some
working
clarity
on it,
here,
on
and
that particular
I think that's the issue, some clarity and some refinement of how that applies is an important issue related to that, so.
Makes sense, absolutely.
And you could work with our committee staff to try to work, I know the Judiciary Committee will be working that as well with you, but we want to make sure that we've covered those issues that have been raised by members here today.
Judiciary Committee, we've been working with them also, and they have amendments already.
So we have been working with Judiciary, and they have amendments that they've been working on too, so we'll work together with them to see that we can craft something that will work for the members of this committee as well.
That'd be great. You have that commitment from me.
I know they've worked, you had a lot of opposition before from Chamber and others, and you've kind of worked to get that opposition off over time, and they're pretty sensitive to frivolous lawsuits and plaintiffs' bar.
With the latest set of amendments, the Cal Chamber and also CompTIA plus a couple other ones also removed their opposition, correct? So,
All right, very good. Seeing no further questions or comments, would you like to close?
I respectfully ask for your vote. Thank you very much. I'll continue to work with.
And we have the commitment to work with the committee consultant and the staff to kind of refine that issue in the Judiciary Committee, so we can.
Absolutely.
Very good. So if I could entertain a motion? So we have a motion from Senator Dodd. Please call the roll.
Motion is due pass the Senate Judiciary Committee. Hill?
Aye.
Hill, aye. Fuller? Allen? Allen, aye. Dodd?
Aye.
Dodd, aye. Galgiani? Aye. Galgiani, aye. Glazer? Aye to no. Glazer? No. Glazer, no. Hernandez? Pan? Wilk?
No.
Wilk, no.
There's 3 votes. We'll hold the roll open for absent members a little bit.